Consent is the legal expression of the ethical principle of autonomy or self-determination. Health professionals seek consent as a defense to an allegation that they have unlawfully touched a person. It forms a defense to an allegation of trespass to the person, which is made up of assault, where a person perceives that they're going to be unlawfully touched, and battery, which is the actual unlawful touching. The law holds the preservation of bodily integrity in high regard and goes to great lengths to protect the autonomy of individuals. This has been the case for over 100 years. The law says that every human being of adult years and sound mind has a right to determine what shall be done with their own body. If we look at that statement in a little bit more detail, it sets the context of consent in healthcare for us. Every human being, we can define the law as rules of human conduct, of adult years, which suggests that things are different for children, and soundness of mind. Does the person have decision-making capacity? The most important part of the whole statement comes next. Has a right to determine. Determination suggests that a person can say, yes please, I know there are side effects to this treatment, but I'd like it. Or equally to say to you, no thank you, I know you've said that without this treatment I may suffer pain or harm or may even die, but you are bound by that person's decision. The extent of the right to determination was well put by a judge called Lord Robert Gough. He said that the principle of self-determination requires respect has to be given to the wishes of a patient. So that if an adult patient of sound mind refuses, however unreasonably, to consent to treatment or care by which his life would or might be prolonged, those responsible for his care must give effect to his wishes, even though they don't consider it to be in his best interest to do so. To this extent, said Lord Robert, the principle of the sanctity of human life yields to the principle of self-determination. We are often told that we must always act in the best interests of our patients, but the issue of best interest is only a matter for consideration when the patient lacks decision-making capacity. In the case illustrated by this picture, a woman was found wandering in the street. It was clear to those looking at her that she'd fallen over on a number of occasions. She was covered in bruises, her clothes were torn, and an ambulance was called. The ambulance recognised her as a woman who had a long history of mental disorder, but they felt that this wasn't a relapse of her mental condition, as her consciousness seemed to be fluctuating. When she was taken to the emergency department, it was quickly diagnosed that she had a badly bleeding duodenal ulcer. The woman was well known to the health service as someone who had professed since the 1970s that she was a member of the Jehovah's Witness faith, and she made it clear that she did not want blood to be used in the treatment of this bleeding ulcer. The doctors caring for her warned her that without blood she could suffer considerable harm and even die, but she was adamant that she did not want the blood. They assessed her decision-making capacity, and despite her mental disorder, they accepted that she had the capacity to refuse the blood. She did deteriorate, and the doctors became concerned about whether they had done the procedure properly. So they went to the court of protection, the specialist court for people who lack capacity, to seek the court's advice. On the evidence before it, the court accepted that the doctors had indeed carried out the assessment of capacity properly, that the woman had understood her options, she understood the consequences of not accepting treatment, and that she'd been able to retain and use that information when weighing it against her religious beliefs to refuse the blood. Sadly, some 8 days after that judgment, she did indeed die, and this shows that the courts are prepared to uphold the self-determination of capable adults, even if it means that that adult will die. Consent goes further than simply providing a defence to an allegation of trespass to the person. It goes to the very heart of the rightness, the correctness of the touching, the treatment and care that you provide as health support workers. A judge once asked that if an invasion of the body of one person by another is potentially both a crime and a tort, a civil wrong, how is it that health professionals, including support workers, can with immunity perform on a consenting patient an act which would be a very serious crime if done by somebody else? We stick needles into people, we use noxious substances on people, and in theatre we even use knives on people. Those would be very serious crimes if they were done in the middle of Carmarthen or Aberystwyth on a Saturday night. The judge said that the answer has to be that bodily invasions in the course of proper treatment stand completely outside the criminal law. The reason why consent to the patient is so important isn't just that it furnishes a defence, but because it's usually essential to the propriety, the rightness, the correctness of the treatment. So if consent is absent and isn't dispensed with in special circumstances by operation of the law, the acts of the health professional will lose their immunity. The law accepts that consent can be given in three different ways. Consent can be given through the expression of the patient. The patient expresses their willingness to be touched. Most commonly, this express form of consent is given verbally. The patient agrees to you touching them. On occasion, where the treatment is more intrusive or perceptually risky, a written consent is required, and a patient is asked to sign a consent form. So the patient expresses their willingness through a written consent form. The third type of consent is called an implied consent, where, in response to a request from you to touch the patient shows through their actions their willingness. The classic example is illustrated here, where if you ask a patient to take their blood pressure, they may hold out their arm and roll up their sleeve. The law treats each of these types of consent as equally effective. The law doesn't mind which form of consent you obtain as long as you obtain it. However, sometimes you need a degree of evidential certainty, you need a degree of evidence to show that you've obtained that consent. Where a procedure is intrusive, where the person requires a serious form of treatment, then we generally ask that person for a written consent. To be valid, consent must have three elements. Consent has to be full. The person has to agree to all of the touching that's to take place. It has to be free from duress. It must be the freely given, voluntarily given choice and decision of the patient. And it must be reasonably informed. None of us would want to make a decision without sufficient information on which to be able to base that decision. Two types of information are required. The first is about the general nature of the treatment. So the person requires information in broad terms. I want to check your temperature. I'm going to put this thermometer in your ear. But then we have to go into the risks inherent in any treatment. We have a duty to go into those risks, and so we have to explain to the patient the risks and benefits of the treatment and what alternative, less risky treatment might be available for them. If a patient were to receive an injection of painkiller, then we would advise the patient that we were giving them an injection for the pain, but we would also tell them that it might make them drowsy, that perhaps they shouldn't walk about, that perhaps it would make them feel a little nauseous. So we're warning the patient about the risks, the common risks inherent in that treatment. We have already seen that the key to a patient's autonomy is what the judges call soundness of mind and what we call decision-making capacity. Consent is now regulated by the provisions of the Mental Capacity Act of 2005. It has been in force since October of 2007 in Wales, and it sets out the rights of all people when it comes to making consent to treatment decisions. It also sets out the rights of people who are found to lack decision-making capacity. It allows people to make decisions in advance through an advance decision to refuse treatment, and it also allows people to fill in a form called a lasting power of attorney for health and care that allows them to choose people they trust to make treatment and care decisions about them should they lose capacity at some point in the future. The law applies to those who are 16 and over. The decisions that can be decided can be wide-ranging, they can be very simple or complex, and they include decisions regarding medical treatment for both physical and mental disorder. The Mental Capacity Act is underpinned by a code of practice. You have a legal obligation to consult the code when you're making decisions for people who lack decision-making capacity. The law requires methodical application of the provisions of the Mental Capacity Act and its code of practice. You therefore have a legal obligation to have regard to the code if you're acting in a professional capacity or for remuneration. The Mental Capacity Act's philosophy is set out in 5 guiding principles under Section 1 of the Act. The first principle says that a person must be assumed to have capacity unless it's established that he lacks capacity. The initial presumption or starting point in law is that an adult has the ability to make decisions for themselves. Generally, as you go about your duties and you seek consent, you can take the decision of the adult and act accordingly. This presumption is rebuttable. The onus is on you if you feel that a patient lacks capacity to show that that patient lacks the necessary capacity to make the decision. We can't make assumptions about a person's lack of capacity based only on discriminatory matters such as a person's age, appearance, their condition, or behaviour. The second principle says that a person is not to be treated as unable to make a decision unless all practicable steps to help them to do so have been taken without success. This principle acknowledges that some people may need assistance to make a decision. It is a conditional clause. It calls for practicable steps, and this requires a balance of risk. The risk of promoting autonomy against the risk of delaying treatment. The threshold for risk is high, and the presumption is that all practical steps will be taken to help a person exercise their autonomy by allowing them to make a decision. The courts say that in order to skip over the promotion of autonomy, a patient would have to face a risk of significant harm before you were justified in saying, we mustn't delay, we must continue with treatment. The third principle says that a person is not to be treated as unable to make a decision merely because they make an unwise decision. Making unwise or mistaken decisions is the ultimate expression of the right to determine, and we cannot use it as an indicator of a lack of decision-making capacity. The courts are very keen to stress that even people with an impairment or disturbance of the mind or brain have the right to make the same unwise decisions, the same mistaken decisions as everyone else. As Sir James Mumby, the head of the Court of Protection, says, all life involves risk, and the elderly and the vulnerable are exposed to additional risks, and to risks they are less equipped than others to cope with. But, he says, just as wise parents resist the temptation to keep their children metaphorically wrapped up in cotton wool, so too we must avoid the temptation always to put the physical health and safety of the elderly and the vulnerable before everything else. If a patient has decision-making capacity, then, like you and I, they're entitled to make decisions, and decisions we may not necessarily agree with. We have to respect those decisions. Those first three principles focus on putting the individual at the centre of decision-making and promoting their right to make their own decisions. The final two principles show that where a person truly can't make a decision, then the fourth principle says that an act done or a decision made under this act for or on behalf of a person who lacks capacity must be done or made in their best interests. We therefore have a legal obligation, a duty, to act in the best interests of a person who lacks decision-making capacity. Because we have a duty to act in this way, any decision we make about best interest is open to challenge. Hopefully, through discussion and consultation, we can resolve any conflict about best interest. But if that isn't the case, then the matter will have to go to court, the Court of Protection, for them to make a final judgment. Any serious treatment will continue until the court makes that decision. The final principle reflects a very important human rights theme. Before an act is done or a decision is made, regard must be had to whether the purpose for which it's needed can be as effectively achieved in a way that is less restrictive of the person's rights and freedom of action. This reminds us that this law allows us, in the case of a person who lacks capacity, for the very best of reasons to interfere in their life. But it is a basic theme of human rights law that where such an interference is necessary, we can only do it to the extent needed to achieve our legitimate objectives. If you like, we cannot use a sledgehammer to crack a nut. We always have to consider the least restrictive way of interfering in that person's life. Restraint, for example, is a very emotive word, but it's a difficult term to avoid under mental capacity law. Amongst other things, restraint is defined as any restriction of liberty of movement, whether or not a person resists. Holding the hand of a person who lacks capacity to stop them stepping out into the middle of a busy road is restraint. We are restricting that person's liberty of movement. But it would be reasonable and proportionate to the risk that the person faces, and so it would be lawful. If we use restraint that is disproportionate, then we lose the protection that the Act offers us, and we could face a criminal charge of ill-treating that person. We've seen that mental capacity is the ability to make a decision. We've seen that it is the key to autonomy. It is based on a test of understanding rather than a professional or status test. And we've been told that we can't assume a lack of capacity because of a person's age, physical appearance, condition, or an aspect of their behaviour. For an issue to be one of decision-making, we have to be able to show that the person is suffering from an impairment or disturbance to the functioning of their mind or brain. That is, the person cannot make a decision because of an impairment or a disturbance in the functioning of the mind or brain. It doesn't matter whether the impairment or disturbance is permanent or temporary. If the treatment is needed immediately then we can treat that person as lacking decision-making capacity. The presence of an impairment or disturbance on its own is insufficient as proof of a lack of capacity. It must be the case that the impairment or disturbance in the functioning of the mind or brain is affecting the person to the extent where they cannot make a decision. To test that, we consider whether that person is able to understand information relevant to the decision, whether they can retain that information long enough to be able to take the information, weigh it against what they believe and want, and arrive at a decision that they communicate to you. The code of practice tells us that a person isn't to be regarded as unable to understand the information relevant to a decision if they're able to understand an explanation of it given in a way that's appropriate to their circumstances. So this allows you to use simple language, it allows you to use pictures rather than words, it allows you to use other visual aids, or perhaps present the information in a language that the person understands. Information relevant to a decision includes information about the reasonably foreseeable consequences of deciding yes or no, or of failing to make a decision. The code of practice tells us that it is important not to assess someone's understanding before they've been given information about that decision. The person being evaluated must be presented with detailed options about their treatment so that their capacity to understand and weigh up those options can be fairly assessed. The code of practice also tells us that it's important to assess people when they're in the best state to make that decision, if that's possible. The person doesn't have to understand everything and every detail about the decision. It's not even necessary for the person to understand all the peripheral detail. What the person under review must understand and weigh up are what the courts call the salient details, the nitty-gritty relevant to that decision. This is because the court says that we must guard against imposing too high a test of capacity to decide, because that would run the risk of discriminating against a person suffering from a mental disability. But they also say that if we follow the provisions of the Act and follow the code of practice, then we are being consistent with that approach. Salient details differ depending on the decision to be made. If we want to test a person's capacity to make decisions about where they reside, then they have to be shown to have understanding and insight into their care needs and the reality of life if they were to return home. For treatment, the salient details are the nature of the illness, including its seriousness, the nature, purpose and effect of the treatment, what treatment options are available in broad terms, the benefits and risks of accepting treatment, and the consequences of refusing treatment. The second part of this test is that the person has to retain information. And again, the law says that the person doesn't have to retain information for a very long time, just long enough for you to be happy that they've taken the information you've provided about their options in, mulled it around, weighed it up, and arrived at a decision. Where you can see that a patient has a short-term memory problem, perhaps a short-term memory problem of less than a minute, then arguably they can't retain that information long enough to be able to weigh it up. Weighing up information, here the code gives guidance concerning using or weighing information as part of the decision-making process. It says that for someone to have capacity, they must have the ability to weigh up information and use it to arrive at a decision. Sometimes, says the code, people can understand information, but an impairment or disturbance stops them using it. For example, there was a case of a lady in need of an urgent caesarean section, but she had a profound needle phobia. She understood that she required the operation, but the panic instilled by the needle phobia prevented her from weighing up her options, and the court decided that she was incapable of making that decision. In other cases, the impairment or disturbance leads to a person making a specific decision without understanding or using information they've been given. In one case, a woman with anorexia nervosa seemed to be unable to weigh up information because, said the judge, her obsessive fear of weight gain meant she couldn't weigh up the advantages or disadvantages of eating in any meaningful way. Finally, the person must be able to communicate their decision to you. This doesn't have to be in writing or in a verbal way. Any action that the person can demonstrate and can convince you whether they're saying yes or no to the treatment is sufficient to form that type of communication. If a person doesn't satisfy you on any one of these 4 points, then you can say that for that decision, the person lacks decision-making capacity. Where a person lacks decision-making capacity, then treatment can only be provided to them if it is in their best interests. Who decides on that person's best interest depends on whether there is somebody with a formal power and authority under the Act. These are known as designated decision makers. If the patient has prepared for future incapacity through having a lasting power of attorney for health and care or health and welfare, then you would have to go to the attorney for consent in the same way you would normally go to a patient for consent. Much more rarely, the Court of Protection may appoint someone to make decisions about a person's health or care, and that person is known as a court-appointed deputy. Where such a person makes themselves known to you, then you too would have to go to them for consent in the same way you would normally go to a patient for consent for treatment. These powers have not been widely adopted, and it will be quite a rare occasion where a patient has one of these in place. So it is often left to health professionals to determine what's in a patient's best interest. But even here, the patient can restrict what treatment you provide through a much more informal instrument called an advance decision to refuse treatment, where an adult with capacity sets down what treatment they wish to refuse and under what circumstances they wish to refuse it. So an advance decision to refuse treatment limits the care and treatment that can be provided in a person's best interest. The advance decision has to be valid, that is, made by a person who is an adult. It doesn't always have to be in writing, but if it's to apply to life-sustaining treatment, it must be in writing. It must be signed by the maker. It must be witnessed in the maker's presence, and it must have a statement that says that it's to apply even if life is at risk. An advance decision to refuse treatment becomes applicable if the person lacks capacity and the treatment and conditions expressed within it apply to the situation that the person now finds themselves in. In a case involving a man with motor neuron disease, he had a very simple, long-standing advance decision in which he'd said that he wanted his artificial nutrition and hydration removed 2 weeks after he lost the ability to communicate. The team caring for him had been caring for him for some 5 years, and they felt it very difficult to withdraw his treatment. But as the court pointed out, this was a consistent and wavering decision that he'd made well in advance when he had capacity, and now he was in a position where he was no longer able to communicate, and that the advance decision was both valid and applicable, and that they were obliged to withhold his artificial nutrition and hydration. Some 2 weeks later, he died from kidney failure and dehydration. The Mental Capacity Act says that we mustn't make discriminatory assumptions about the care and treatment a person who lacks capacity should receive, simply based on their age, their appearance, their condition, or their behaviour. In one case, a severely learning disabled person was admitted to hospital for emergency treatment for acute renal failure. The view of the health board was that he should not be considered for dialysis or for kidney transplant because of his learning behaviour. The court held that the possibility of a kidney transplant should not be ruled out on non-medical grounds and discriminatory grounds because this person had a learning disability. Dialysis had to proceed and the person should be placed on the transplant list. The best interest requirement also reminds us that we must involve the person who lacks capacity in decisions about their care and treatment. Even where we conclude that a person can't give a valid consent to treatment, we must not exclude them from the decision-making process. There's a very good pragmatic reason for seeking consent and working within a climate of consent. You will know from your experience that the effective delivery of care and treatment generally requires cooperation from a patient. By continuing to involve the patient and taking care to explain the treatment to patients, you're more likely to foster rapport and cooperation from that patient, making the delivery of care and treatment easier and much more effective. In determining best interests, the Mental Capacity Act sets out a checklist of factors. You are required to consider this checklist as part of making the best interest decision. You're asked to consider all the relevant circumstances of the case. Every patient's case will be slightly different, and you're asked to consider the circumstances that the patient finds themselves in. This includes, but isn't restricted to, the benefits and burdens of the treatment. You're then asked to consider whether capacity is likely to be restored and whether the decision can wait until the patient can make it themselves. You're also asked to consider your motivation. The Mental Capacity Act makes it very clear that when it comes to life-sustaining treatment, we mustn't be motivated by a desire to bring about a patient's death. A ward sister in Crewe in Cheshire was overheard saying to two frail older patients on her ward, whilst giving them prescribed doses of sedation and analgesia, "Come on now, it's time you died, it's time you went, lie back and go to God." And she was then overheard speaking to junior members of staff saying, "I wish these patients would hurry up and die. They're blocking our beds. We need the beds. Why don't they die?" When they did die, the police investigated, and although post-mortems revealed nothing other than natural causes for cause of death, what the ward sister had said and done led a jury to convict her of attempted murder. She was jailed for 5 years and struck off the professional register on her release from prison. It is vital, therefore, that you record your motivation and don't give any hint that you were motivated by a desire to kill a patient. You're asked to consider the person's wishes, feelings, beliefs and values, and to consider those wishes very carefully as long as they're not irrational, impractical in the sense of you physically being able to carry them out, or irresponsible with respect to the amount of money it would take. You're also required to consult with others where it is practicable and appropriate to consult them. That includes anyone named by the person to be consulted on these matters, anyone engaged in caring for the person or interested in their welfare, such as family members, friends or informal carers, and anyone with a power of attorney or a deputy that's been appointed by the court, even if they don't have the authority to give consent. They're still very good people to speak to because they know the individual and can give an opinion on what's in their best interests. Now, these individuals do not tell you what to do. You simply consult with them as part of the best interest decision-making process. There may be occasions where there is nobody to consult, and here you may have a duty to instruct an independent mental capacity advocate for those so-called unbefriended people who lack capacity. Under the Mental Capacity Act, there is a need to instruct an independent mental capacity advocate where we keep a person in a hospital for 28 days or more, other than where they're detained under the Mental Health Act. So if a person lacks capacity, is unbefriended, there's nobody else to consult with, and we intend to keep them in hospital for 28 days or more, then we must instruct an IMCA. The other occasion is where it is proposed to provide serious treatment to the patient by an NHS body. In this sense, treatment involves giving the treatment, withdrawing the treatment, or withholding the treatment in three key circumstances. The first is a case where a single treatment is being proposed, but there's a fine balance between its benefit to the patient and the burden and risk it's likely to entail. The second is a case where there is a choice of treatments and a decision as to which one to use is again finely balanced. And the third is where what's being proposed would likely to have serious consequences for the patient. This might be where we intend to withdraw artificial nutrition and hydration, where that's the only source of sustenance for a patient, with a consequence that the patient would die. The role of the IMCA is to act as a consultee. They will speak to the patient, will try and represent the patient's views. They are allowed to see the relevant parts of the patient's record, and they will discuss with you your decision over treatment. They will usually provide you with a written report that you can then use to help you decide on what's in a patient's best interests. Now, in return for assessing capacity, determining best interests, instructing an IMCA where one is necessary, the Mental Capacity Act provides you with a flak jacket protection through something called the care and treatment protection. But there are limits to that protection. You cannot, for example, ignore the formal powers of the Act. If a person has authority under a lasting power of attorney for health or care, you must seek their consent to the care and treatment of a person who lacks capacity. The same would be true for a court-appointed deputy for health and care who had that authority. You mustn't ignore the wishes set out in a valid and applicable advance decision refusing treatment. If you do, you lose the protection of the Mental Capacity Act. The second key limit to the care and treatment protection is restraint. The full definition of restraint is the use or threat of force where a person's resisting, and any restriction of liberty of movement, whether or not that person resists. Restraint is permitted, but only when you reasonably believe that it's necessary to prevent harm to that incapable person, and that it is proportionate both to the likelihood of the harm and the seriousness of that harm. So it is crucial that to benefit from the protection of the Act, you must justify its use through a written record. So you must record that you have objective reasons to justify the restraint and to show that it's necessary. You must be able to show that the person being cared for is likely to suffer harm unless proportionate restraint is used. You must not use restraint just to make your life easier. And if restraint is necessary to prevent harm to a person who lacks capacity, it must be for the minimum amount of force for the shortest possible time. So we've seen in these slides that consent is the legal expression of the ethical principle of autonomy or self-determination. It provides you with a defense to an allegation of unlawful touching, and is regulated by the Mental Capacity Act of 2005.